Welcome everyone again to the University of New Mexico Law and Mental Health Series, weekly discussions of practice and science featuring experts in behavioral health and the law. This series is run by the Division of Forensic Behavioral Sciences of the University of New Mexico's Department of Psychiatry and Behavioral Sciences in support with the New Mexico Behavioral Health Services Division. I'm Anthony Perillo. I'm the Forensic Psychology Training Director here at the University of New Mexico. For our talk today, if you have any questions for our presenter, make sure you enter them in the Q&A box. You can enter those anytime you feel comfortable, but do know that we hold questions until the end. We try to get to as many as we can, but oftentimes it's not possible for us to get through all of the questions. If you are pursuing continuing medical education credits, there will be a sign-in sheet posted in the chat box shortly. If you're pursuing APA continuing education credits, there will also be a link in the chat box, but around 10 till near the end of the hour. Make sure you keep an eye on the chat box then, bookmark the link or copy it if you're not going to open it before the webinar closes, and make sure you save your certificate after you complete the survey because we don't have access to completed surveys after the fact. If you missed last week's talk in the series, Dr. David Shapiro's discussion of commonly asked questions in forensic mental health practice is now available on our YouTube channel. The recording for this week's talk should also be available on our YouTube channel sometime later this week, and the PowerPoint slides will be accessible for people that registered for the series later this week as well. As a heads up for next week, we have Dr. Mark Martinez who will be discussing risk management considerations and forensic evaluations. But coming back to this week, I'm very excited to introduce you to today's speaker, who'll be discussing competency evaluations in immigration court. This is Dr. Maria Aparcero Suero. Dr. Aparcero Suero is a staff psychologist at Patton State Hospital in California, where she completed her forensic postdoctoral fellowship and the year before that, completing her predoctoral internship. She obtained her Ph.D. in clinical psychology with a concentration in forensic psychology from Fordham University. Dr. Aparcero Suero's research examines the validity of psychological and forensic assessments and emphasizes their application with culturally and linguistically diverse adults. Her dissertation research involved adapting and validating the fitness interview test immigration court version for use in immigration court with English and Spanish-speaking populations. She was awarded several grants to complete her dissertation from the American Academy of Forensic Psychology, the American Psychology Law Society, the International Association of Forensic Mental Health Services, and from Fordham University directly. She also received the Diversity in Clinical Science Dissertation Grant Award from the Society for Science of Clinical Psychology. Dr. Aparcero Suero is developing a manual and user guide for the FIT-IC to disseminate to clinicians, aiming to ultimately facilitate the consistency and quality of immigration competency evaluations, the core content of what she's going over today. So, Dr. Aparcero Suero, Maria, on behalf of the University of New Mexico, thank you so much for joining our series, and we're very excited for you sharing your expertise with us today. I'll go ahead and toss it over to you.
Yeah, well, thank you so much, Anthony, for having me here. I've been following this series for, I think, since the beginning. So to me, it's an honor to be here today as a presenter. And thank you for the introduction as well. So here are a few kind of housekeeping information about CEs. I believe you will be receiving a PDF copy of this. So I'm kind of like move kind of quickly, but you will receive a link for like your CE certificate at the end of the presentation. For disclosures, kind of to point out that Anthony Perillo and myself, we don't have any relevant financial relationship or any commercial interest on this presentation. So the views expressed in this presentation today are those of myself, and they don't necessarily represent the views, policies, or positions of the University of New Mexico or Patton State Hospital, where I currently work at. So the learning objectives for today, as you probably saw in the announcement, is to describe the legal context of competency evaluations in immigration court, including the legal standard for competency to participate and represent oneself. Also, to identify relevant psycholegal abilities in the evaluation of competency to participate and represent oneself in immigration court proceedings. And lately, we're going to discuss how to prepare and approach immigration competency evaluations with an emphasis on cultural considerations. So this is what I prepared for today. My goal is first to kind of talk about how immigrants may end up in deportation proceedings. Then I'm going to touch on immigration respondents' legal rights and how they're different from the defendants in criminal court. Then we're gonna jump into the competency legal standard in immigration court and some of the legal background related with this topic. And then what is the core process for determining whether an immigrant respondent is competent. And the bulk of the presentation today is gonna focus in how do we do these evaluations? So how do we prepare if we get a referral? How do we conduct evaluations? And then some cultural and practical considerations, as well as some advice of how you can communicate your findings. So let's jump in. So the U.S. Custom and Border Protection and the Immigration and Custom Enforcement, these are both offices of the Department of Homeland Security. And these are the offices that are usually the ones, apprehended immigrants. So CBP are the ones that are at the border, and they have contact with immigrants when the immigrant arrived to the port of entry and they try to enter the U.S. without legal documentation, or they try to seek admission at the port of entry. On the other hand, ICE is the ones that are on grounds. So they're already in the US, so they have contact with immigrants that may be unlawfully present in the US. So these are immigrants that don't have legal documentation or that they have overstayed their visa. And they also apprehend individuals that may already have a green card. However, they have committed a crime that is considered to be a deportable crime. And these may include aggravated felonies, crimes involving moral turpitude, crimes related with firearms, controlled substances, or domestic violence, just to name a few. So once apprehended, these organizations, the agencies, they may permit the immigrant to depart voluntarily. They may process the immigrant for expedite or administrative removal without giving them the opportunity to present or appear before an immigration judge. They may give them the opportunity to, apply for affirmative applications such as asylum, or they may refer them to immigration court proceedings right away. Just to point out, I'm of course oversimplifying this material. Immigration court and immigration law is highly complex. So for the purpose of today, I just try to really simplify to be able to present it in a way that at least you have a structure and can go for that to educate yourself. What is important to point out is that all immigration cases can end up in deportation. So that option is always present on immigration proceedings. So the stages of immigration proceedings. So if there are, again, two agencies. So we have the Citizenship and Immigration Services, also called as USCIS, and this is under the Department of Homeland Security. And then we have the Executive Office for Immigration Review, and this is kind of under the Department of Justice, and this is what we usually refer as Immigration Court. So UCIS is the one that is going to process any affirmative application. So they are the ones that process the initial application for asylum, or when people apply for work visas or student visas. So usually the case gets to an officer. So to put an example, it gets to an asylum officer, and this asylum officer evaluate whether the person meets the criteria for asylum. If the officer agrees, then they can grant asylum in that moment, or after reviewing the materials. But if they disagree or they don't believe that the person meets the criteria for asylum, then they deny the application and refer the person to immigration proceedings. So when we are in immigration court, the first encounter is a calendar hearing. So usually in this stage is when it needs to get established whether or not the person is removable, whether the person meets the criteria for deportation. And this is something that the Department of Homeland Security has the burden of proof. So they have to prove by clear and convincing evidence that the immigrant respondent is removable. If they found that the person is removable, then we go into deportation proceedings. So now in deportation proceedings, it's up to the immigrant respondent to prove that they do meet criteria to stay in the US, that they meet criteria for humanitarian relief or any other type of protection. So they can stay here and avoid deportation. Okay, so kind of moving into the legal rights that an immigrant have in deportation proceedings. So the reason why I want to touch about this is because immigration court proceedings are under civil law. So what that means is that immigrants do not have the same rights when they're going through immigration proceedings that defendants have in criminal proceedings. So for example, immigrant respondents don't have a right to an appointed counsel, even if they're unable or they cannot afford to pay for an attorney. So what that means is that if you cannot find an attorney, afford one, or find one pro bono, a lot of respondents will proceed with their proceedings representing themselves. Also, they're often required to testify to support their case. As I said, immigrant respondents have the burden of proof. They have to prove that they are able to stay here, that they meet the criteria. Therefore, a lot of the times, being able to demonstrate that you meet those criteria, relying on being able to tell your story, to explain why you have to come to the US and why, for example, you are unable to return to your country, or what is the risk that you may encounter if you return to your country. Additionally, they don't have a right to be competent before their case can be determined. And this is kind of like the topic of today, so I will talk more about this. But in general, even if a person is found to be incompetent due to symptoms of mental illness or cognitive deficits, the proceedings will still continue. That is no restoration process, and the case will not put on hold as it happened in criminal proceedings. Immigrant respondents do have a right to a fundamentally fair process. So these include having a reasonable opportunity to be heard, to respond to the charges threatening their stay in the US, to present probative evidence in their defense, and to examine and object adverse evidence and cross-examine witnesses that are presented against them. Formally, the standard of proof tends to be more probable than not. What is very different to beyond reasonable doubt that tend to be the criteria in criminal proceedings. But what we have found is that actually immigration judges have a lot of discretion. And at times the decision on these cases tend to depend on the type of the case, the state in which it may be, the proceedings are happening, or other sociopolitical factors. And I'm sure you guys know what I'm referring to in this regard. Okay, so let's now dive in a little bit more into what is competency in immigration court. So the competency legal standard is relatively new in immigration court, especially if you compare it with criminal court. So it was established in 2011 in the case of the matter of MAM. It was established that a person is competent to participate and represent oneself in their immigration proceedings if they have a rational and factual understanding of the nature and object of the proceedings, if they can consult with the attorney or representative if there is one, and if they have a reasonable opportunity to examine and present evidence and cross-examine witnesses. So a related case is the Franco Gonzalez v. Holder. So this was a large-scale class action suit that happens in California, Arizona, and Washington. And kind of the outcome of that case was that individuals that are detained, so they are in immigration detention, they are unrepresented, so they don't have a legal representative, and they're found to be incompetent to represent themselves due to mental illness or cognitive deficits. Now, after this case, these individuals are entitled to a qualified representative. It's important to point out that that doesn't mean an attorney. It can mean a law student, an accredited individual, or other reputable person in the community. And these initially only applied to California, Arizona, and Washington. Later, the Department of Homeland Security and the Department of Justice, after the holding in the Franco case, they decided to release nationwide guidelines and national policy in which those decisions were extended nationally. And they also provide more information about what are the different functions that the immigrant respondent must be able to do in order for us to say this person is capable of representing themselves. So they said that the immigrant respondent must have a rational and factual understanding of the nature and object of the proceedings, but also about the legal rights. And this includes the right to representation, the right to present and examine an objective evidence, the right to cross-examine witnesses, and the right to appeal. And here, what is most important is whether they're able to waive or to assert those rights and do that in a rational manner. They also established that immigrant respondents must have a reasonable ability to make decisions about asserting and waiving their rights, as I just mentioned, to respond to the allegations and charges in the proceedings, to present information and respond to questions relevant to eligibility for relief. And then they also went ahead and defined what mental disorder is. So mental disorder under this standard is a significant impairment of the cognitive, emotional, or behavioral functioning that substantially interferes with the ability to perform any of those functions. So as you notice, they don't talk about specific symptoms or specific disorders, but more globally, any symptom or impairment that interferes with the immigrant respondent's ability to do any of these functions. So that nexus between the impairments and the ability to do these functions is what we need to establish in these evaluations. And then a related issue, you may be in a situation where an immigration attorney comes to you and they say, I'm representing a client and I want you to assess whether they are able to testify on their own behalf during their immigration proceedings. So in these cases, the immigrant may be represented by an attorney or another immigration agents that tend to be the referral source, but they're noticing some difficulties in their ability to testify or tell their story in court. So they want you to look at whether there are some impairments around that topic. So it's a competency evaluation, but in these cases, the person is represented and is more targeted about their ability to tell their story on the stand. So some of the questions that the lawyers may present to you is the respondent impaired in their ability to tell their story coherently and answer questions accurately? Are the aspects of their presentation that might give an inaccurate impression of deception, lying, or withholding information? And then are there disability accommodations that could allow them to testify more accurately? And I'm going to be touching a little bit more into what are the things that the information that we can provide to help answer these questions and help the court make a determination on these cases. Before we move on into how competency is determined, I want to make sure that this is clear. Yes, there is a lot of overlap between the legal standard of competency in immigration and criminal court. However, there is also unique differences that I want to highlight. For example, those related to self-representation. Immigrant respondents, even when they have legal representation, they are expected to have a much more active involvement in the immigration court proceedings that a defendant is expected to have in their criminal proceedings. And this is because they have the burden of proof and because usually the primary way of explaining why you meet the criteria for relief is attached to your narrative, to your story. Therefore, they have to testify and be able to tell their story. So this is the main difference between immigration and criminal competence. What it is similar, though, is that the legal impairments must arise as a result of psychopathology or poor cognitive abilities. So our job as evaluators is routinely assess the examinee's mental health and cognitive functioning and how those impact those psycholegal functions. So in a nutshell, this is kind of what happened in court. So first, immigrant respondents are presumed to be competent, okay? So unless there is an indicia or someone raised a doubt that the immigrant respondent might not be competent, then the proceedings will move on as usual. But if there is someone raised a doubt, there is an indicia, then the judge must do their evaluation, their investigation. Actually, they can review records, they can ask questions to the respondent, and if they believe that they can make an answer or make a determination about the respondent's competency, they can go ahead and make that determination. However, if the immigration judge believes that a mental health evaluation is needed to inform their opinion or their determination about competency, then they will come to us. Or in other cases, maybe if they have a legal representative, maybe you're being hired by the legal representative. So then your job will be to identify functional psycholegal impairments caused by mental health symptoms or disability. The competency hearings in immigration court and non-adversarial, so meaning everyone are supposed to contribute to kind of find out whether this person is competent or not. And it must be proved by preponderance of the evidence that the immigrant is incompetent. Then if the immigrant is found to be incompetent, then as I mentioned before, there is no restoration process. The case will continue. However, the immigration judge is supposed to put procedural safeguards to ensure that this person is still able to have a fair hearing. Okay, so now let's move on into how do you prepare? So let's say you get a referral, someone contact you and say, hey, like, can you do a competency evaluation of an immigrant respondent? And then you say, of course, I'm ready. So the first thing, as most forensic evaluations, you want to talk to the referral source if you can. So you want to understand what are their concerns, why they're kind of questioning whether or not this person is competent. What are the behaviors that they have experienced, or the difficulties that they might have observed or experienced when communicating with the immigrant respondent. And then you want to get as much information as you can about the specific of the case. As part of this evaluation would entail asking specific questions about their own case. If there are records available, which is not always the case, but if there are records available, you want to review those records. Mental health records, medical, educational, and then if those records are not available, you may want to think about which records you may want or would like to review, and then like ask for those records. And then if you can identify collateral informants, this can also be very helpful in case you need them after meeting with the immigrant respondent, or in case the immigrant respondent has difficulties participating in your interview. You also want to familiarize yourself before meeting the respondent with their immigration background. So reasons for their migration, information about their country of origin, what is their primary language and whether they speak any other languages, what is their culture, their education level, and whether they have had any prior contact with immigration or criminal proceedings. It's also helpful to get information about the criminal justice system in their country of origin. In particular, it's important to be aware of potential misunderstandings that the respondent may hold based on the type of legal system in their country of origin. So for example, if the respondent are coming from countries with an inquisitorial system, these are non-adversarial process, then these individuals may have more difficulty understanding that the immigration proceedings that they're facing, they're adversarial. And therefore, they may have difficulties understanding what is the government attorney's role in their proceedings. So if you know that in advance, then you can make sure that you address those in your evaluation and make sure that the person is understanding the adversarial nature of the proceedings that they're going to face. Also, any information that you can gather about the social perception of law informants and the legal system in their country can be very helpful, as well as any information about their socioeconomic and political context of the country of origin. And one of the reasons why having this information can be very helpful is, for example, we know in a lot of countries there is a lot of corruption and abuse of authority. So if individuals come from those countries, they may have negative beliefs, or they may have, well-founded mistrust towards the law enforcement and towards the court proceedings. And that might show in your interview. However, it's very important to be able to tease apart whether those are reality-based or whether those are delusional. So the more information you may have about the country of origins situation and circumstances, it may help you to be able to tease those apart. Also, you want to familiarize yourself with any culturally normative behaviors, any cultural manifestations of distress, or religious spiritual practices. Also, if you are conducted the evaluation in another, like in another language or the language of the immigrant respondent, it's important not to assume that maybe you use the same vocabulary. So for example, I do a lot of evaluations in Spanish. However, there is regional differences in the terminology that we use when referring to legal proceedings. So the more information you can know before meeting with the respondent, like maybe different words that are used to refer to the same core personnel, then the more the better you will be able to do these evaluations and kind of change the terminology to ensure that the immigrant respondent is really understanding what you're asking. Also, you may want to start thinking whether or not you're going to need an interpreter before you meet with the respondent, and then whether there are any available or relevant assessment tools that you may want to utilize. Okay, kind of like competency evaluations, and I'm sure most of you know these, but these are forensic mental health assessments. So what that means is that your role as the evaluator is to be impartial, accurate, and weight all data and rival hypotheses. So the role of these evaluations is not to advocate. So I know a lot of people, including myself, we come to this work because we're interested. We may have immigration background ourselves, or there is something about this work that is appealing to us and we want to be part of the solution and not part of the problem. However, it's really important that we self-monitor and that we engage in consultation so that our own immigration experiences, advocacy, and empathy do not overwhelm our objectivity. So we can maintain that neutrality and try to be as impartial as possible in these evaluations. So the evaluation process, in a nutshell, these are different components of a competency evaluation. So first is the clinical interview. And so this clinical interview should be targeting, kind of assessing what are the current psychological and cognitive symptoms that the person is experiencing. And this may or may not impair the person's competency. So that's something we're going to have to establish as we gather information in our evaluation. It's important to know that a diagnosis is not necessary or not sufficient in competency determinations. So it's more about what are the symptoms that the person is experiencing and how those symptoms interfere with the capacity to participate and understand their proceedings. Also, you always, as in any forensic evaluation, you want to assess for response style and any evidence of over-reporting. You also want to critically assess the need and adequacy of assessment instruments. So usually assessment instruments are very rarely used in these situations. And that is usually because there are time constraints. Sometimes, honestly, there are no tests that is going to answer the psychological question. There is no test that is going to tell you whether or not the person is competent. And also because of, cultural differences, linguistic differences, sometimes we just don't have tests that has been, or assessment tools that has been translating and researched in a population that resembles the client that you are examining. And then the bulk of the evaluation is assessing the psycholegal abilities. The psycholegal abilities are informed by the legal standard. And what I found very helpful in doing these evaluations is to ask questions, go from general topics to case specific. And that has usually helped me establish rapport with the clients. And then something else is moving from open-ended questions and then closed-ended questions, especially with individuals that may have cognitive deficits. They may have difficulties responding to like open-ended questions, but then if you are able to use multiple choices or forced choice questions, you are actually able to better assess the capacity and their knowledge. And what is also very important in these evaluations is to provide education and reassess whether the person has been able to understand that information and apply to their own case in order to differentiate a person that is incompetent from someone who just doesn't have knowledge due to their unfamiliarity with their immigration court process. And also, if ultimately you believe that this person is presented with impairments, you may be asked to provide recommendations for safeguards. So now I'm gonna talk more about the psycholegal abilities. I know that how to do a clinical interview and the other parts has already been addressed in prior webinars. So I'm just going to focus on what is very unique about these evaluations, and that is the psycholegal abilities. So for that, I'm going to be using the framework of the Fitness Interview Test Immigration Court. This is an immigration competency assessment that I adapted as part of my dissertation. So I adapted it from the Fitness Interview Test Revise, which is a competency assessment tool that was developed to help do competency evaluations both in the US and Canada. So this is a semi-structured interview, and the FIT-IC, I developed it both in English and in Spanish. So really, competency assessment instrument is not necessarily not sufficient to do this work. However, given that there is not a lot of information out there to train yourself or like kind of really know what needs to be assessed in this evaluation, so the FIT-IC, what it does is kind of compile what are the different psycholegal abilities that we should be looking at. And it also offers questions that you can ask in order to gather the information that you're gonna need in order to come up with the ultimate, or like to inform the ultimate decision about whether or not the person is competent and what are the impairments that they're presenting. So the FIT-IC, what it did is that provide kind of operationalization of the matter of MAM standard in a way that mental health professionals can understand what are the different things that should be looking at in these evaluations. So the FIT-IC have 4 sections that are broke down into the different competency related abilities that we should be looking at. So under section 1, understand the nature and object of the proceedings. So we saw this as part of the legal standard in the matter of MAM. So we want to ask questions to see whether the respondent understand the role of different court rule personnel. So these involve the judge, the government attorney, the defense attorney, if there is one, and the witnesses. And what is very important to focus on is if they understand the adversarial nature of these proceedings. We also want to know if they understand the legal process and the court procedures and the different stages and the role that they have in the different stages of the process. If they have been arrested, we also want to ask questions to see whether they understand the reasons for their arrest and whether or not they gave any information to ICE officers and whether they understand how that information can be used in the proceedings. We want to know if they understand why they are at risk of deportation, why they may not have the documentation to be here in the US. And then depending on where they are in the proceedings, whether or not they understand that they will have to admit or deny charges during their calendar hearing, this can be very important. And these will primarily come up in cases that are not as straightforward, if you will. So these may come in cases where the person may have a green card, but they're being in deportation, they're being referred to deportation proceedings because they believe that the crime that the person was convicted of falls under that category of deportable crimes. So in these situations, the strategy might be to let the government to really prove that that is the case. So it's important for the immigrant to understand the difference between being in that calendar hearing and their role during that process versus in deportation proceedings when they do have the burden of proof. We also want to assess whether they understand the possible consequences and their legal rights, as we mentioned before, based on the legal standard. So we want to ask information about the forms of relief that are most viable to them. Do they know them? Do they understand what needs to be proved? Do they understand the possible consequences of the proceedings? And we need to go a little beyond, yes, I can be deported, but what does that mean for you? What are the personal implications of being deported? In a lot of situations, deportation can mean being separated from family that is in the US. It may mean that you don't have access to treatment that you're getting here, or it may be that you're going back into a country that you haven't been there for a long time, or you have never been there, but that is kind of like your home country based on documentation. So it's very important that we go into details to know whether the person truly understands what it means and the possible outcomes of these proceedings. whether they are able to engage in a rational discussion about what outcome is more likely, and also do they understand their legal rights. And here, as I mentioned before, is not whether or not they understand them, it's more about, are they able to talk about the advantages and disadvantage of waiving these rights? Are they able to explain the underlying thinking and rationality for waiving them or asserting them? That's the capacity that we want to assess. Also, their ability to communicate and make decisions. So are they able to respond to questions about their case? Are they able to do so rationally, coherently, and in a well-organized manner? This is really touching on, are they able to testify? Are they able to tell their story? Are they able to make arguments about how they meet that criteria for relief so they can stay here? Are they able to identify evidence that they can present to support their case? And also, are they able to identify evidence that may be present against them? And can they refute that? Are they able, during the interview with you and kind of during the court, are they going to be able to stay focused? Are they going to be able to understand what other people are telling them? Are they able to tolerate the stress and to manage their behavior in the courtroom? So those are things that we want to evaluate and to pay attention to. And then also, you want to see whether the person is able to collaborate with a defense attorney. So in a lot of cases, even if the person doesn't have a defense attorney, you may be asked to evaluate whether the person will be able to work with a legal representative. So you want to see whether they're able to collaborate in developing a defense, if they're able to take advice and to kind of evaluate the pros and cons of different strategies and kind of engage in that rational decision making regarding how to move forward with the case. Do they understand the relationship between the attorney, the confidentiality aspect of that relationship? Those are things we want to look at. So now I want to focus a little bit into cultural and practical considerations, things to keep in mind when we're doing these evaluations. So as I mentioned before, it's really important that we distinguish between lack of knowledge or legal information and impaired functional abilities. So this distinction is particularly critical in the context of immigration court. And this is very important in order to minimize the risk of misclassifying a respondent as incompetent. Given that low levels of knowledge are expected, especially when the person just arrived to the US, we cannot assume that not having the knowledge means that they are incompetent or that they have impaired capacity to do that function. So we want to make sure that we provide that psychoeducation, and then we assess whether the person is able to gain that information and then apply to their own case. So these may look, for example, what I found in my research is that many immigrants lack a basic understanding of the immigration court. However, when provided with education, most of them, they were able to understand that information and then apply to their own case. And then also at the end of the evaluation, I will go back and I make sure that they're still retaining that information. Something else that I found in doing this work is that there is a lot of misconceptions regarding the immigration legal system. And these misconceptions tend to be based on their knowledge of the criminal justice system in the US or in their country of origin. So for example, in my research, I found that 98% of the participants were not aware that they did not have the right to a court-appointed counsel when facing immigration deportation proceedings. So a lot of them, because they're familiar with criminal court, with criminal court, they say, oh, well, at some point, they will give me an attorney. Well, that was not the case. And this may be preventing them for trying to find legal representation before going to their court appointment. Also, a lot of them believe that there was a jury in this proceeding when that is not the case. So a lot of these misconceptions are based on like TV shows and movies and information that they are exposed about the criminal justice system that is not consistent with the reality of immigration proceedings. Also, the respondent's level of acculturation can impact factual knowledge of the legal system. So what we found is that those that are more acculturated to the US, they tend to have more knowledge about the US culture, about the legal system, and also being able to speak the language, like being able to utilize resources in English, that tends to be associated with increased knowledge of the legal system and the legal rights. So something to keep in mind that especially when you're evaluating someone who is low acculturated, maybe just came to the US, you may need to spend more time in that education process. A lot of these individuals that also have a lot of difficulty understanding the adversarial nature of the proceedings. For example, in my research, 60% of the participants did not know the government's attorney presented charges against them and advocated for their deportation. So a lot of individuals, as I mentioned before, they may come from different legal systems like inquisitorial systems, and they think that the government attorney role is only to find the truth. Okay, so if they don't understand that actually in these proceedings, the government is trying to prove that they meet criteria for deportation, there may be a risk of sharing potential damaging information with the government attorney. So it's very important that we kind of assess this piece. Another aspect that tend to be difficult for individuals is the difference between the legal assertion of innocence versus telling the lie. And this will not be relevant in every evaluation. As I mentioned before, a lot of times in calendar hearings, it's very obvious that the person doesn't have documentation. They don't have a visa, or so in those cases, it will be very easy to demonstrate for the government that this person meets the criteria or is deportable. However, in other more complex cases, it's very important for us to assess that the respondent understands the difference between, asserting your innocence and letting the government establish or proving that you are deportable versus lying or telling a lie, which is very relevant, especially in the second part of the proceedings when they do have to testify. It's very important that they do understand that they cannot lie and that can actually be used against them. As I mentioned before, in these evaluations, it's extremely important to differentiate cultural mistrust from paranoia or other type of delusional beliefs. And a lot of times it can be very helpful, of course, as in any interview, you need to assess how fixated the person is and how strong that belief is. But and a lot of times knowing information about their home country, that can help you kind of see whether their beliefs are based on evidence and reality versus on delusions. In a lot of countries, we also see kind of an over-reliance on authority. So you also want to assess whether the person is maybe being over-reliant on their legal representative because they may be depressed and very passive and they may not care about the outcomes, and that may be more related with mental illness versus they're from a culture where you just do kind of what authority tells you. Another important thing is understanding that when individuals may be speaking a second language, they may not present a lot of emotionality. And sometimes it can be important to assess whether that is due to the fact that they're talking in a second language or there is something else. Is there any psychotic symptoms, negative symptoms going on? And then in general, what we have found is that immigrant respondents do benefit from systematic education, and this education should be more widely accessible to them. And then the last step that I wanted to talk about is the safeguards accommodation. So these are things that you may still be asked to address in your report. So if there are relevant impairments that you identify, you may be asked to provide safeguards or recommendations for safeguard or accommodations that can be put on the proceedings to mitigate those impairments. Of course, you may be asked to provide these recommendations, but ultimately it's up to the judge to make the final determination about whether or not this will be put in place. But in conversations with other mental health professionals and immigration lawyers, these are some of the accommodations that they have previously recommended. So for example, medication and mental health treatment, letting the lawyers to ask leading and close-ended questions, to take frequent breaks and minimize distractions during the hearings, to allow for the person to not testify in court and maybe only submitting like a written testimony. If the person doesn't have a legal representative, one of those accommodations or recommendations can be to provide them with legal representative, or maybe having a trusting person together with them. And in general, a big one tends to be just providing psychoeducation to the court. So just to provide an example, one of the areas in which psychoeducation tend to be pretty common is in the context of trauma responses, of symptoms of trauma. So in a lot of situations, mental health professionals can provide a lot of context in how trauma may impact memory and the person's presentation when telling their story. So you may want to explain how trauma may impact the respondent's ability to remember the events, to tell them accurately and in a chronological way. You may want to explain that fragmented recollections are quite common when someone has gone through severe trauma, and that maybe they present as flat or without emotions, but that doesn't mean that they're making this story up. It may just be a response to their trauma experiences. So that's an area in which not only in competency evaluations, but in other type of in other type of immigration evaluations, you may be asked to do is just to provide psychoeducation to the court. And lately, there was another webinar here about considerations of how to do report writing in immigration evaluations. So I don't want to go into much detail with that, but I wanted to make sure that I do kind of highlight a couple things. So with respect to mental health and medicine, the audience is entirely lay. So our communications need to be understandable to the judge, to the legal representatives. So we want to make sure that we minimize using professional jargon and that our reports are easy to understand for anyone that may not have the background and education that we have. The report should only contain relevant information, and relevant information is the information that will allow to respond to the psycholegal question. This is extremely important in immigration court. A lot of immigration lawyers have pointed out that a lot of in immigration court, any discrepancy, any minor changes will be utilized kind of against the respondent to kind of show that they are lying or they're not being truthful. So it's very important that we don't add information that is not needed, so we avoid that information to be misused. It's very important, as I mentioned before, that you create that nexus between the symptoms that the person is experiencing and how that impacts their psycholegal capacity. And compared to a criminal court, you may be the only expert in this case. So your report is extremely important, as it may be the only one. And most likely you won't be asked to testify. So that's even telling us that our reports are extremely important. So we need to make sure that they're well written, that they address the information that is relevant, so that they can actually be used to inform legal decisions in these cases. So I know I touch on a lot of things, but here I left some of the articles that I utilize and that I feel like if you want to learn more about this topic could be helpful. So I just put them here. And then lately I just wanted to mention, so I utilize the framework of the FIC for today's presentation. If you're curious to know more about the FIC, you may think it will be helpful for you to use in your evaluations and are curious to know how to get access to the FIC and potentially collaborate with me in kind of making sure that this instrument is in good shape and can be useful in clinical practice, please email me here. There is also the link to my dissertation. It's a long read, but I hope it's useful. It's over 200 pages. But, I really try to make sure that I was be very thorough and that read can be helpful. So reach out to me if you want to chat more about this topic. And thank you everyone for being here.
Yes, thank you so much, Maria, Dr. Aparcero Suero, for a very helpful, thorough overview here of a unique application of what I think a lot of the audience, is more broadly familiar with competency evaluations in criminal courts, but seeing the very unique and stakes here of where we could apply some of that in immigration court as well. The interest in here is clear. I'll say that, I mean, your last discussion there really ties into several people had commented in there. Are there versions that are available? Would they be able to have an access to copy? People hoping to be able to reach out to you for additional questions. So yes, this has been very well received, and thank you so much for that. We do have a number of questions from attendees. Feel free to enter those. Continue to attendees if you have any additional questions. And we'll go back to that slide with Maria's contact information and all that a little bit later after we have the QR code here a bit longer. In the chat box is also the link for the CEU survey if you need to access that directly there as well. Somebody asked in terms of broad applications of this. Somebody said, maybe I missed this during the presentation, but where were the majority of participants you interviewed from? I wonder if there would be differences between Latinx and other immigrants, for example, East Asian immigrants.
Yes, so thank you so much for asking that question. Yes, so everyone that I have interviewed were from Latin America, and these evaluations were conducted in Spanish. So yes, the good point. There probably be other areas of concern or differences if the person comes from another country. So for that, what I recommend, there has been some publications about cultural differences, and so I feel like maybe reading those articles can be very helpful to maybe have a better sense of maybe how mental illness is expressed in different cultures, and maybe some information about their, their legal system in their home country. So a lot of the information that I have presented today is primarily based on research with Latin American immigrants. So there may be things that are applicable to other cultures, but that may not be the case. So thank you for pointing that out.
Wonderful. Yes, highlights, a foundational piece, but a lot of work and to still be done for a number of different people that are affected in immigration proceedings. Somebody asked, thinking about the idea that in competency evaluations, education for areas that the person is unfamiliar with is key. They added, apparently the evaluator is often responsible for educating the respondent about the legal proceedings they face. Many of us are not very familiar with these unique aspects. Where does an evaluator receive such training to be knowledgeable in the way that they would need to for immigration court?
Yeah, that is a great question, right? So for these evaluations, it's extremely important that you have an understanding of the proceedings, because otherwise you're not going to be able to ask these specific questions to provide the psychoeducation that is needed, again, to kind of differentiate the lack of familiarity with impairment. So being here today is a great first start to getting trained. I think reading the literature on this topic, the reality is that there is not a lot out there. And that's one of the reasons why my dissertation kind of happened, because I was very frustrated by the fact that there was nothing kind of to inform mental health professionals on this area. But I feel like what I have done is to make sure that I review the literature on the topic, that I try to talk with lawyers about the unique aspects of the immigration process. And if you're working with an attorney, I will definitely ask about any specific things that you should know about the person's case. There is a lot of information on kind of more from the legal side that can be helpful for you. So I hope that some of the articles that I put there can be helpful, but if not, reach out to me. But that's kind of what I will do, is just to go to the legal literature and also to the mental health literature, kind of to inform yourself and then ask questions.
Wonderful. Thank you.
Sorry, Anthony, to cut you off, but my understanding is that there is a training that is offered by the EOIR, that trains mental health evaluators that want to do more of those Franco evaluations. So if that's an interest of you, I currently don't have the information, but I know that that's something that has been done in the past. So if that's something that you're interested, I'm happy to try to find more information about that. But yeah, right now there is not really a lot out there other than kind of the literature.
Certainly, thank you. Somebody asked about the general lack of corroborative records and having to rely so much on self-reports would seem like a constant limitation, requiring a lot more in the way of, your more impressions, your judgment to answer the referral question. What do you do to maximize support for your competency-related opinions, lower the margin of error as much as possible?
Okay, so I guess I'm not sure if I completely understood the question, but kind of like the fact that we have to rely so much on the respondent self-report, like self-report, and how you capture that.
That's ultimately what I'm getting at the question, where in this particular case, it seems far less likely that you'll have, say, collateral records to compare to, and you're relying much more on directly what is the person saying and what is the impression I'm getting in the room.
Yeah, so what I do think will be helpful, again, if you have information, at least information from the referral source, even if that is only kind of the letter of the petition that kind of highlight the charges, I think you must have that. So at least you understand the person's case. In a lot of the interviews I have done, I found that sometimes the immigrant that don't really understand completely the reasons why. So you do want to have that kind of notice to appear in front of an immigration judge that kind of lay down these charges. And then I think in terms of not having collateral, you're gonna have to just rely on like doing a very good clinical interview. And again, the presumption is that the person is competent. So unless you see symptoms that are like during your presentation that are interfering, if you don't see that, that's probably indicating that the person is competent. So you want to make sure that you do a very good clinical interview, and the topic of competency is focusing on the present moment. So again, if you don't see any impairments during your evaluation, then probably your opinion would be that this person is not presenting with significant impairments.
As you mentioned, people are presumed competent. If there is a hearing with an incompetent immigrant, what are some of the legal accommodations that are put in place by the court to allow a fair immigration proceeding?
Yeah, that is a great question. So there is a lot of discretion on this area, and they have been, I have talked with a lot of lawyers, and some of the lawyers think that there is nothing that you can put in place to offer a fair hearing to a person who cannot participate in their proceedings. So there are people who believe that kind of dismissing the case is the only possible solution, but you do have a range of things, and that's kind of like the safeguards that I was talking about. Those are safeguards that mental health professionals and legal professionals have previously recommended, and those tend to be the ones that tend to be implemented. However, I haven't talked to immigration judges, and there is not really a good documentation about what actually happens in these proceedings. So that's as much information as I have, but those are some of the samples. So I think the one of asking leading questions, that tends to be a big one. And then a lot of the lawyers also advocate for not having their client testifying during the court proceedings, but just maybe submitting, a narrative, like a written testimony.
Wonderful. We are approaching the top of the hour. We have time for a few more questions. Because people were very interested in your contact info, and we've had this slide up. If you could go to the prior slide with your contact info and of course, the QR code for your dissertation. It seems like a lot of people are interested in that. Somebody asked, are these cases always pro bono? And if not, how are these typically funded, or where does payment come from?
That's a great question. And my understanding is that I do think in general in immigration court, there are a lot of cases that are pro bono or kind of low fee. However, that's not always the case. So it would really depend on who is your referral source. So I believe for the evaluations, these more like Franco evaluations that are the referrals coming straight for the court. I think I recently heard someone that they might pay $700 per evaluation. But then if you're working with private attorneys in a lot of cities, like big cities like New York, sometimes they already have programs, like the Legal Aid Society may already have programs to provide free counsel to immigrant respondents, and they may able to pay the evaluators. But in general, I think unless you're being hired by a private attorney, when I don't know how often that is, you may get paid, but not a lot in comparison with what you may get paid in criminal proceedings.
Sure. And one final question. Somebody asked if the use of interpreters impacts the outcome of these cases from your findings.
Yeah, so for the ones that I have done, I have always been able to do in the native language of the immigrant respondents. So having had the opportunity to work with interpreter in the context of these particular evaluations. However, in kind of thinking ahead of future research using the PIC, that would be one of the things I would like to look at is how, introducing a third person and having that translation process may impact these evaluations. But in terms of the use of interpreter, there has been other talks on that. So I would recommend looking into that and kind of how to more effectively work with interpreters in any evaluations, because I don't think we get a lot of training in how to work with interpreters, and there may be some strategies that we can utilize to make sure that we can work with them the most efficiently possible.
Well, there's clearly so much more work that can be done in this area. So Dr. Aparcero Suero, thank you so much for building on this conversation and your work in this area and sharing all your expertise with us on the work that you've done clinically and research-wise here so far on competency evaluations in immigration court. It's very, very enlightening and I think very helpful for a lot of people to see the impact that we can have. So thank you so much for that.
Thank you so much for having me.
And that wraps up this week's Law and Mental Health series. As a reminder, next week we have Dr. Mark Martinez. We'll be discussing risk management considerations and forensic evaluations. We hope to see you then for another great discussion of issues in behavioral health and the law. Until next time.